The next point is actually very significant. The attack must be unlawful. Now, on this point, that the attack must be unlawful, we run into a very interesting difficulty with Article 51, no matter what language it's written in. So listen again. Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member state until the Security Council gets involved. Did you hear the word unlawful attack? No. The word unlawful attack is not there. So it is not entirely clear what they are thinking about. The notion of an unlawful attack is critical to the principle of self-defense. That is, it makes a difference in the way the world thinks, whether Egypt attacks Israel or Israel attacks Egypt. But the way this charter is written, both sides can claim self-defense because an armed attack has occurred. If an armed attack occurs, then it is open to either side to claim self-defense. This is not acceptable. The principle of unlawful attack has to be written in to the charter and understood as a fundamental principle, the way we intuitively understand it, as a fundamental principle of international law. The third point, that is actually, the third point is that requires separate mention. The attack has to be imminent. Now, this is a highly debatable point. You know that the charter says, if an armed attack occurs, if you use that standard strictly, that Israel behaved improperly in the '67 war. But I take it for granted that Israel behaved properly in 1967 when the Egyptians closed the straits, they mounted their troops on the border, they threatened the destruction of the state, and it was just a matter of time until the invasion occurred. Now, in the standard street law of self-defense, there's absolutely no question that you have a right of self-defense against that kind of imminent attack. No one says you can only use self-defense after you've been attacked. This would be ridiculous. You have to wait till the other guy throws the first punch. I think this idea must have come, it reminds me of my father's experience in the First World War. It probably comes from the days of the cavalry, where we imagined that attacks occurred on horseback, and once they crossed the line, what we would do is push them back. So we didn't imagine that there were missiles crossing the line. We didn't imagine that the attack could occur by mechanized means. We didn't imagine that once the attack occurred, maybe the war is going to be over. We thought that, well, some horses will cross the line, and we will push them back. That's the only way I can explain this ridiculous language, if an armed attack occurs. Just about every commentator I have read on this, including Yoram Dinstein, my primary critic, has said that this must mean imminent attack. He intuitively uses the standard of individual self-defense. I don't think there's any other way to do it. By the way, when Dinstein gets to the subject of unlawful attack, he doesn't know what to do. Because he read in my book that I discussed the unlawful attack, he says, I don't understand this. How it's possible? Because it's not in the charter. I'm a positivist. I read the charter, it's not here. There's something wrong, and I can't explain it. I think sometimes you just have to say, they made a mistake. There's something has to be read into the charter. And what we have to read into the charter is the attack has to be unlawful, and it has to be imminent. On the defensive side, there are three factors as well. The three factors are: the defense has to be necessary, it has to be proportional, and it has to be intentional, knowing or intentional. These are standards that are derived from the basic criminal law. The difference between a necessary attack and a proportional attack is absolutely critical, even though my general reading in international law suggests that no one has ever noticed the difference. The two terms are interchanged all the time. Necessary and proportional, necessary and proportional. But they are totally different concepts. The attack is necessary. Think about the Getz case. This was a major issue. Both necessity and proportionality were issues in the Getz case, because the argument was you didn't have to shoot. You could have just pulled the gun. So shooting was not necessary. You had less costly means available. And if you have less costly means available, you cannot bomb the cities of the other side. It's not necessary. The problem of Israel's bombing the highways north of Beirut was not proportionality, it was necessity, a much more basic issue. It wasn't necessary to do that. When you start bombing beyond the scope of, is this a necessary means to a legitimate end, then you're in the field of illegal behavior. But even if the conduct is necessary, there is an additional test of proportionality. And this is a wonderful problem in comparative criminal law. I'm sure that Merkel remembers this from our class. The German case of the orchard owner who shoots the thief running away with an apple. German law basically says that you can use all force that is necessary under the circumstances without recognizing a principle of proportionality. So if you have to use deadly force to protect your property, you're allowed to do so. Now, I don't know how much we share this view in international law. What I do know is that if we are threatened with a permanent occupation, we will do whatever is necessary to end that permanent occupation. I always like to find like Swedish and Norwegian students in my introductory class, because they're the most peace-loving people in the world. And I say that, okay, let's suppose that Norway builds a shopping center on 3 square miles of Sweden, and they're willing to pay you for it. You say you have to get rid of that shopping center. You have to take off you cannot occupy our land. No, just tell us how much it's worth and we'll pay you. Sorry, it doesn't work that way. You just can't pay for New Mexico. You cannot pay for occupied territory. The other state will claim an inherent right of self-defense to terminate the occupation, to terminate the aggressive occupation of the land. And I'm afraid that our sentiments probably are that if there is no other way to terminate the occupation but to kill the occupying troops, then you kill the occupying troops. The alternative would be to say, well, I'm sorry, we just have to accept the occupation because from the point of view of international decency, it is too costly to get rid of it. Or we'll pay damages. They're willing to pay damages. No, damages is not right. Territory is sacred. And therefore, and this principle is certainly recognized more in international law than it is today in the law of property. In the law of property, when a mistake like this occurs and one neighbor builds on the land of another neighbor and it's a mistake, the court might say, pay damages. You don't have to tear it down. But we, international law, would say, no, we have a right of self-defense against this aggressive intrusion.